This lecture will be concentrated on the most important or landmark judgment relating to Hussainara Khatoon vs. State of Bihar. In the year 1979, the judgment was delivered by the apex court, and the very introduction, if we would like to discuss on the case Hussainara Khatoon vs. State of Bihar, it revolves around under trial prisoners in the central prison of Bihar, which was filed a writ petition under Article 32 of the Fundamental Rights relating to Habeas Corpus, and in particular invoking Article 21 of the Constitution for speedy trial of those under trial prisoners in the prison of Bihar. So a writ petition about the very facts of the case, that the writ petition concerning habeas corpus was filed before the court under Article 32 of the Indian Constitution. So the very writ petition before the apex court was for the release of 17 under trial prisoners. It depicted a sorrowful picture of the administration of justice within the state of Bihar. An outsized number of persons, which even included mainly the categories like women, children, and other deprived categories of poor sections, and that they all were locked behind the bars and were seeking for the trial as well as their release. Thus, the state of Bihar was advised to file a revised chart which was focused and clearly mentioned the year wise break from the under trial prisoners after safeguarding the prisoners into two categories. That is, one charged with minor offences and others who have been charged with major offences. But although this direction was not carried by the state, the petition acknowledged that the under trial prisoners who have done minor offences, as they were imprisoned for a long period of 10 years, those people were considered to the poorest of poor, that were not even able to afford an lawyer, and also they were refused to grant bail. So the issues before the court is relating to invoking Article 21 in relation to, as it is concerning right to life and personal liberty. So speedy trial of those under trial prisoners fall under the very Article 21. So the question raised in the leading is that whether right to speedy trial comes within the ambit of Article 21. Then the second most important part of the issue is what is the essence of speedy trial under criminal justice. So the Supreme Court's observations in this important leading case, where the court realized the plight of under trial prisoners whose denial of fundamental rights, so the apex court gave stress often unable to interact a lawyer and disregarding human rights were the main issues which have focused. And also to be solved, the court realized the denial and disregard of private liberty. The court also found that the under 12 prisoners of Those lists which was filed before the court they need those who are in jail for a longer period. Even the period of time was too long enough, then the prescribed time range that they could have been sentenced to jail if convicted. The court recommended the state also as to central government by directing them to list out the entire number of cases, location of courts of magistrates and courts of sessions, mainly the articles under the judgment cover Article 14, which is relating to right to equality and equality before law, and Article 21, that is concerning right to life and personal liberty, and Article 39A, which concern regarding free legal aid. So, the Supreme Court of India held that the state cannot deny the constitutional right of speedy trial and equal access to justice should not be denied on any grounds. So, finally, we would like to discuss the very judgment delivered by the apex court in this important leading case. The apex court observed that and directed that the under trial prisoners whose name and particulars were filed by the petitioner, it had because imprisonment like false imprisonment was considered to be an illegal and also violative of their fundamental rights as enshrined under Article 21 of the Indian Constitution. The court also mandated that in time of charging bailable offences they need to be produced before the magistrate on remand dates. The government ought to name a legal advisor of their own expenses for making an application for bail. A quick trial is much required for securing justice. The court also ordered both the government as well as High Court to display the particulars regarding the location of the courts of magistrate and courts of sessions in the state of Bihar, along with cases pending in each court on 31st December 1978. They were also asked to state the rationale of pendency of cases. On next remand dates, the under trial prisoners should be produced before the court in order that the state government ought to designate a lawyer of its own expense. The state cannot avoid its constitutional obligation to supply speedy trial to the accused by way of pleading. So, free legal service to the poor as it is enshrined under Article 39A, which was inserted under 42nd Constitutional Amendment Act of 1976 to the poor, and therefore the needy people is an essential elementary factor of legal aid. Another direction by the Honorable Court was to supply the under trial prisoners charged with bailable offences free legal aid by the state on their next remanded dates before the magistrates. The court further held that detaining them for any long would be illegal and is clearly against the fundamental rights, which are the basic rights being recognized by the Constitution of India under Part 3 of the Constitution, and in particularly as enshrined under Article 21 has right to life and personal liberty. As those prisoners are behind the bar through, they are longer, even if they committed minor offences, so they should be immediately give bail and being released by the Court of Magistrates and Session Courts, and it was a direction and order issued to the state by the apex court for speedy trial, and those four convicts are entitled to war. Behind the bar, they must be provided free legal aid by the state as per the provisions under Article 39A to provide speedy justice and free legal aid to those poor litigants and undertrial prisoners inside the prison. And this was a landmark judgment delivered by this apex court in regards to speedy trial and in relation to free legal aid. And this landmark judgment led to some important other judgments delivered by the Supreme Court regarding speedy trial and free legal aid in the successive years. So it left a lasting impact over the apex court in furtherance of speedy trial and free legal aid in successive judgments of the apex court.